May it please your Honour, my name is Lutton, spelt Lutton, initial M, and I appear for the plaintiff Burns Ever After Propriety Limited. Today I'm instructed by Smith & Jones Solicitors. Your Honour, there are two matters before the court today. The first relates to the misleading representations made to my client during pre-contractual negotiations purchasing a BD60 cremator. The second issue is the counterclaim by the defendant to stop my client from entering into contract for additional equipment. My client alleges that the defendant misrepresented the cost per cremation being $85 compared to the actual cost, which has exceeded $400. As a result, my client has suffered loss and seeks to rescind the contract and receive a refund. Your Honour, finding in favour of the defendant would be a violation of the Australian Consumer Law, Competition and Consumer Act 2010, Commonwealth Schedule 2, Section 18. Section 18 is met as they are in a commercial arrangement and this issue is not contentious. However, under this provision it states a corporation must not, in trade or commerce, engage in conduct that is misleading or deceptive, which is in dispute. The defendant is caught by this provision as he has made misleading statements by telephone and emails during negotiations about the running costs. Clearly, this statement was made to sell the BD60 model and induce my client into contract without reasonable grounds as provided for in Section 4(1) of Schedule 2 of the Competition and Consumer Act 2010, Commonwealth. The deception was exposed when the defendant wrote on the 10th of May 2018, revealing the calculations were based on 5 cremations a day with 24-hour operation quoted on maximum throughputs. These calculations did not meet my client's specifications after specifically outlining his needs to the defendant. The defendant was silent on this incorrect information when it was a critical factor in his decision to purchase. Your Honour, what it amounts to is a non-disclosure of information that my client would reasonably expect to have been disclosed prior to the contract signing. As a result, once discovering the specifications were wrong, my client notified the defendant on the 11th of May 2019 and again June 29 that he wanted to return the cremator because it was not working and end the contract and receive a refund. The defendant may dispute this claim and argue that the misleading statement was reasonable due to the BD60 being a new model and that my client knew these facts as he was to be the flag bearer and write reviews for the cremator. Your Honour, no evidence has been provided by the defendant to support his argument for these statements being reasonable and does not meet the provision Section 4(2) of the Australian Consumer Law. Your Honour, if you look at the context of this case and apply the objective test, it shows my client is an ordinary person who is new to the funeral business. My client relied on the defendant, who is a manufacturer of cremators, for their experience and technical ability to provide precise specification. This argument is supported by Atlanti and Kruger, 1956, State Report of Queensland 306, Clause 9, in that a representee is entitled to take the representor at his or her word and is not obliged to make an inquiry of his or her own. My client agrees. He knew the model was new, but without the misleading representation, he would never have entered into this contract and instead would have purchased from a competitor, which he has been forced to do. In relation to the recession, there are no limits to be met as my client has evidence in Kruger who acted promptly upon discovering the misrepresentation and did not affirm the purchase. Recession in the Kruger and this case depends upon equitable principles and the question whether they can be restored to their earlier positions. To support this, Atlanti and Kruger and JA and JB Boyle Propriety Limited and Major Furnace Australian Propriety Limited 2019, Queensland District Court 75 at 150, were at a stage where it was possible to restore both parties back to risotto if the defendants took actions to protect their own interests. The defendants did not collect their property at the time notified, and the property became worthless due to the time lapsed. My client cannot be held responsible for damage to the BD60, as the defendant had 14 months to recover the cremator but took no action. This should not prevent recession for my client. In conclusion, the defendant made representations without reasonable grounds and withheld information that would have allowed my client to make an informed decision. My client asks that you find in favour of his case and consider remedies under Australian Consumer Law, Section 2371 for loss and Section 243A to void the contract and Clause D for money refunded. Your Honour, the second matter today is the defendant counterclaiming to stop the plaintiff from denying purchase of the coffin, coaster and ash processor within 6 months from successful installation of the BD60. The defendant had an expectation and assumed that my client would not be free to withdraw from their legal relationship. My client employed that a continuation of business relations may flow on the back of the successful installation of the BD60, and if that had happened, a legal relationship may have existed. The defendant knew this, and my client argues that the interpretation of successfully installed wording is contentious. The implied conduct and statement is unclear and ambiguous and cannot be taken as inducement to the defendant, as in Lutton and Hately, 1993, Volume 152, Commonwealth Law Report 535. Lutton involved a land sale where it was held that inducement must be clear and seeking instructions was not clear. My client's offer was not capable of leading a reasonable person in this way the defendant is relying on, and as a reasonable person would not believe the installation was a success. The argument is supported by Judges French, Kiffel and Bell in High Court case, Crown Melbourne and Cosmopolitan, when they stated certainty is paramount when estoppel is pleaded. Business relations have deteriorated due to operational issues, and because of this, the uncertainty of their business relationship ever recovering would seem unlikely, and any assumptions made about the promised contract is dismissed as either party could have withdrawn due to no formal terms being agreed upon. Finally, the defendant states that he would suffer a disadvantage if the contract is not allowed. However, the defendant himself has failed to act by not delivering the additional equipment within the 7 days as confirmed in his email dated 29th of June 2018. Based on these facts, the defendant's counterclaim fails to meet the necessary elements for equitable estoppel against my client and should be dismissed. Your Honour, that concludes my submission.